The state has a plan for your money, but it may not be the one that you want. If you die without a will or a trust, that means your estate falls under the intestacy laws of your estate. It will go through intestate succession, which means that a judge is going to determine what happens with your estate. Your personal items, your assets, your real property, all of those things are going to be left up to the state's laws to determine how they get distributed. This is a legal framework that treats everyone the same, regardless of your wishes or desires. In North Carolina and South Carolina, intestacy laws follow a rigid family tree structure. This means that your next of kin are prioritized. For example, if you're in North Carolina and you die without a will, your spouse doesn't necessarily get everything. They may actually have to divide assets with your kids. This could include the family home or retirement accounts. Early in my career, I actually saw this play out in real time. There was a young woman and her husband who owned a small business. We've done some basic financial planning for them. We were just beginning to start the process to help them out as business owners when I got a call one day. She told me that her husband had died unexpectedly. He had had a heart attack. But even more frightening than that, he had died without any life insurance and they did not have a will. So she actually had to go through the intestacy process for the state of North Carolina, where she actually inherited her home with her 3 small children. So imagine she's had this massive loss. She's going through a significant life change, and now she doesn't even own her house outright. She had to go through the court system to get the ownership actually changed from her and her children to back in her name. And this was all so she could refinance the property and keep it. It was a complete mess. This leads me to point out that during the intestacy process, spouses do not necessarily inherit 100% of the assets. Even though you are married, intestacy rules are going to apply if you do not have a will or a trust. This may be major for blended families where you have a second marriage, because not only do spouses not inherit everything, you also can't really disinherit a spouse either. So it could create a huge issue when you have certain assets that you want to go to your children and certain assets that you want to go to your spouse. This can create an emotional and a financial strain, especially if the surviving spouse was expecting to be able to remain in the home or inherit the home outright. Another thing that can happen is important loved ones or special relationships may be completely left out of the process altogether. Stepchildren, close family friends, people that are not necessarily immediate family, all of these relationships could be completely left out. Even if they lived with you or you were supporting them financially, the intestacy laws don't care. They will be left out of the process unless you've made legal arrangements. Here's an action step you could take right now. Ask yourself, if something happened to me today, what would I want to happen? Who would I want to inherit certain things? Are there certain assets or belongings I want to go to certain people? Do you have your answers? Now, compare that to what would happen under intestacy laws. The courts don't move fast, especially when you're gone. When you pass without proper planning, your estate is going to go through probate, which is a court administrative process to settle out your estate, pay off final debts and bills, and ultimately transfer assets. It also can be costly and stressful for your heirs. Without a will or a plan, everything has to go through probate. This includes your bank accounts, your investment accounts, your real property, retirement accounts, your belongings. Everything has to go through full probate unless you've got specific account titling or beneficiaries named that would avoid the probate process. Even if you verbally have told someone that they would get some of your belongings or that they would get the house, that doesn't happen without the legal mechanisms in place. Time is a big deal. In North Carolina and South Carolina, We're talking 8 to 12 months for a probate process to play out. This timeline can depend on a number of factors. It could depend on the court's backlog. It could depend on whether or not you have disagreement amongst heirs or disputes about whether or not there is a valid will or a not valid will. It could also depend upon the complexity of the estate, or if there's going to be challenges between creditors and people who are wanting to make a claim against the estate. These types of delays and stressors can add up and create even more costs for your family. If your family or your heirs are required to go hire an attorney to help them navigate the probate process, this could ultimately result in another 2 to 5% of your probate estate's assets lost in cost or expenses. This is money that could have been used for bills, medical needs, or future expenses. In my opinion, perhaps the most egregious thing that can happen during the probate process is that certain accounts could be frozen. Think about checking accounts, savings accounts, investment accounts or brokerage accounts that maybe your family is depending on for banking purposes or paying bills and kind of doing life day to day. Well, if you don't have the mechanisms in place to transfer those assets efficiently, the probate process could require those accounts to be frozen until it's sorted out. That means there's no access to those funds, and the financial institutions aren't going to act unless they have court documentation requiring them to act. It can create real life hardship and delays when it's unnecessary. I'll leave you with this. You don't have to be rich to have an estate plan. Just be intentional. Estate planning sounds like something that should be only required for rich families who just have millions and millions of assets. In my opinion, it's simply about being intentional. Ask yourself, if I weren't here, what would I want to happen? Who relies on me? How can I make things easy for them if I'm no longer here? With a few powerful tools like a simple will, maybe even a simple trust, you can significantly alter the experience that your loved ones are going to have to go through if you are no longer here. I tell people all the time, let's control what we can control. Let's have a plan in place so that if something were to happen, we can at least eliminate a lot of the stressors or the financial burdens that are going to take place. No, we can't divorce ourselves from the emotions and the emotional toll of losing a loved one. But the last thing we want to do is create financial stress or administrative stress at a time when that's the worst thing that could be added. It's already going to be a difficult process dealing with grief. Let's not compound that by adding complexity and financial stress. Not having a plan is still a plan. It's just not your plan. It's the state's plan. Are you feeling overwhelmed trying to put together a retirement plan, or do you have some confusion about your estate plan and how that's going to work? We help couples in the Carolinas build retirement plans and organize their estates with clear and simple strategies. If that sounds like you, click on the link and schedule a call with our team today. Do you know someone that had to go through probate without a will? Share your experience in the comments below. It could really help someone know what they're up against and what they need to avoid. Are you ready to go deeper? Click on the next video and we'll talk about the 4 essential estate planning documents that everybody should have. I'll see you there.